Topic 1 is human rights. So this is we'll have a look throughout at the different syllabus requirements as we go through, so you can see exactly what you're required to do, and we'll cover all of that content. So you have it all with you to help you prepare the best that you can for your exam. So the first aspect of topic 1 is being able to describe your key terms. And those key terms range from human rights to royal commissions and everything in between. So let's get stuck into looking at each of these. So human rights are the fundamental rights that all people have by virtue of being human beings. So just because we're humans, we have these rights. And it doesn't matter what race we are, our gender, our age, nationality, or religion. So everyone has the same rights. They're fundamental and they're equal for everyone. So they are defined as the supreme, inherent, and inalienable rights to life, to dignity, and to self-development. So human rights are defined internationally, nationally, and locally. So different countries can have different human rights and different definitions of human rights. Because we've got those different levels and different lawmaking bodies in each of those areas. So in terms of the Australian context, we've got a bunch of human rights that you're probably familiar with. Things like a fair trial, privacy, adequate standards of living, life and liberty, education and work are all our fundamental human rights. And we'll have a look soon as well at the different types of rights in terms of express and implied rights. But these are those fundamental human rights that are express and that everyone has in Australia. So states. Now this is something that can be a little bit confusing because when we think of states, usually we think of Australia as having lots of states within it. So we've got Queensland, New South Wales, Victoria, etc. And all of those districts are states. But in human rights, states have a different meaning. So states are actually countries that are recognized as having legal standing under international law. And the different criteria that are needed to be defined as having that legal standing are these. So defined territory, one government, and a permanent population. And they also need to have the ability to enter into relationships recognized by law with other states, so other countries. So territory is about the area. We know that the area that Australia covers is defined, that is defined as Australia. One government, we have one government in this country. We also have a permanent population, so people are permanently living here. And we do enter into relationships and negotiate with other countries as well. So those are the things that are required to be recognized as a state with legal standing in international law. So in human rights, Australia is a state. We have a bunch of different terms that are often used interchangeably, but it's important to have an understanding of each of them. So covenants are binding agreements between states. So they're a type of treaty, and that's why these different terms are often used interchangeably. Now, treaties are also formal agreements between two or more states that define and modify their mutual duties and obligations. So they're entering into an agreement, and that agreement is putting into words what their obligations are, what that country is required to do for whatever it is that agreement is on. So the term treaty is often used synonymously with both convention and covenant. And we can see there at the bottom, those three terms all basically mean a legally binding agreement between states. So a convention as well is a binding agreement, and it's also used synonymously with those other terms. But conventions are stronger than declarations. So declarations is a different category because conventions are legally binding for any government that have signed them, whereas a declaration, when you think of that word, it's about declaring something, saying something, but that's not actually in writing. It's not an official thing that's binding. So when the UN General Assembly adopts a convention, it creates international norms and standards. And once that convention is adopted by the General Assembly, member states can ratify the convention, which means that they're promising to uphold it. We'll have a more detailed look at ratification shortly. But governments that violate the standards set forth in a convention um, can face some kind of consequences from the UN as a result of that, because they've made this legally binding agreement. They've introduced potentially legislation that upholds the ideas that are contained in the convention, but then if they violate that, then they would face some kind of sanctions as a result. We have two different types of treaties. One of them is multilateral. So this is about more than two nation states are forming an agreement. And that we can, of course, take from the part of the word multi, which is just like multiple, more than two. And bilateral is a formal agreement entered into by two nation states, and bi means two. So that's how you can remember that difference between those two categories. Now, a signatory treaty. So the term signatory is referring to a state that is in political support of a treaty and is willing to continue that process, continue the engagement with the treaty process to potentially result in some legislative changes and ratification. But it's just that indication of support, and it's not quite that official level yet. So this is about intent. The intent is codified as a signature, as the word implies, and that signature is submitted to whatever the international body is that has power and oversight over that particular treaty. And in a state that is a signatory to a treaty, that means that the treaty hasn't entered into force in that area yet. So it isn't an official piece of legislation yet. Now, ratification is the next step up. So this is when a signatory country, so a country that has submitted its signature to say that it is intending to follow that treaty, this is when the country is actually implementing domestic legislation to uphold that treaty. So the process of full adoption of the obligations imposed by a treaty or covenant into Australian law for us, or it could be another country, by the passing of legislation through the federal parliament that mirrors and enacts the treaty obligations. So you're signing you're signing up to this idea of the treaty, and then you're actually ratifying that, solidifying that promise by implementing the legislation that reflects the principles within the treaty. So, a little bit more of a look at the difference between signing and ratification. So, Australia is a party to the United Nations Convention on the Rights of the Child. And so each state has legislation that protects children to uphold the principles of that convention. Now, for example, in Queensland, we have the Child Protection Act, and the principles are also mirrored in the Family Law Act, which is a Commonwealth Act. So, signing is that idea of expressing the intention to comply with the treaty. And for this example, that happened back in 1990 in August. But then implementing the domestic legislation to ratify the treaty didn't come until December of that year. So you can see that there's a little bit of a gap between uh, indicating that you're going to continue that process and sign up for that treaty, and then actually implementing the legislation. There are processes that would have to take place for the legislation to actually be passed and drafted and all of those processes. So that's why there's a bit of a delay there. Sovereignty is another concept that you may have heard of before, and it's something that you need to be able to describe as part of this unit. So, this is the concept that a government exercises full control over everything that's happening within a geographical or territorial limit. So, it can pass laws and it can enforce those laws in that area, and it exists as an essentially independent legal and political body as well. So it has full control, and the laws and the processes of other countries are not relevant here because it has control over its territory. So Australia, as a nation state, claims sovereignty over its territory, and then by default, that means over the people within that territory as well. But this isn't necessarily straightforward for Australia and for any country that has sort of groups of First Nations people and Indigenous people. So, for example, in Australia, sovereignty is not something that all First Nations people believe um, they ever relinquished. So they thought um, that because Australia was invaded uh, by Captain Cook and people from overseas, they have said before, and some people continue to say that they haven't relinquished their sovereignty because it was never something they agreed to. This was originally their land, and they will always be our First Nations people. So in Australia, sovereignty is vested in the Crown in Parliament, so the monarch and the Parliament. So we have our monarch over in England, um, and and then we've also got the Parliament here in Australia with the Australian government. Bill of Rights. So a Bill of Rights is another type of formal declaration, and it is a declaration of the legal and the civil rights of citizens in any state, country, or federation. And it's all about protecting the rights of individuals from being violated by anyone, whether it's the state itself or individuals within that state. A Royal Commission, that's something that a lot of us would have heard of before. So, in the Australian system of government, it's the highest form of inquiry. So, we've got lots of high profile issues that have had royal commissions to find out more information about what has happened, what the situation is with things that are concerning in society. So, it's independent of government, and it's about matters that are of public importance and usually public concern. So they have broad powers, the Royal Commissions, and there's lots of different processes that can take place as part of Royal Commissions. You can have public hearings, call witnesses under oath, and compel evidence from lots of different sources. Royal Commissions make recommendations to government about what should change. So it's all about conducting a really in-depth investigation, lots of research into the issue, writing a report that includes recommendations, and handing that down to the government for it to consider and ideally act on. So the next section of the syllabus, you need to be able to describe the main features of international law that are developed from the International Bill of Human Rights. And we've got a few different aspects to look at here. So let's go through each of these. First of all, the Universal Declaration of Human Rights. So this is a document that was written by representatives within different legal and cultural backgrounds. So the idea here is, of course, people from different backgrounds are going to have different things to bring to the table, different perspectives on issues, different understandings of what's important in society and how society should work. So, so this Universal Declaration was written by a range of different people to make sure it was reflective of that diversity that we have in the world. And then the Universal Declaration, it sets out all the fundamental rights that require protection from all the different nation states. And it includes civil and political rights, so things like the right to life, to liberty, and to privacy. And it also includes economic, social, and cultural rights. So the right to social security, health, and education are examples there. So it's a pretty broad example. And then on the other hand, we have more specific ones that are within the International Bill of Human Rights. One of them is the ICCPR, or the International Covenant on Civil and Political Rights. So there are a number of things that are encompassed in this. Overall, it declares that all people have a range of civil and political rights, and it was adopted in 1966 and entered into force in 76. So some basic human rights that it includes are the right to life. You can see here that there are overlaps between things. So the Universal Declaration of Human Rights also says that we have the right to life. So there is overlap with what these different pieces cover. But the ICCPR also says that we have the right to a fair trial and freedom from torture. Now, most rights are not absolute and are subject to limitations for legitimate purposes. So we, as I mentioned, will look at this idea of express and implied rights. Here, this is about being absolute or not absolute is a little bit different to express and implied. Basically, absolute means that there's no limitations, there's no exceptions, but in most cases, rights aren't absolute because there can be different scenarios, different circumstances that make it legitimate for that right to not be relevant in different scenarios. And another one is the International Covenant on Economic, Social, and Cultural Rights. So this declares that all people have a range of rights in these areas, and we can see some examples down the bottom here. So you can see that there are a lot of social rights, but in terms of economic, right to employment, right to enjoy just and favorable working conditions and to form a union as well. So we often hear about different unions in Australia. So we are a signatory to this covenant. So everyone in Australia has the right to form a union. For example, there are teacher unions, and they advocate for teachers' rights. So favourable working conditions, when we hear about people who aren't paid correctly or don't have safe or sustainable working conditions in factories or whatever that situation may be, we hear about how it is a violation of their human rights. So that comes under this covenant. Social is really broad. So we've got things like right to training, right to social security, protection of the family unit. And you can see as well there are some things that are a bit of an overlap, because of course things that relate to society also often relate to the economy. Society is kind of integral to everything. So working conditions is also part of the social as well as the economic. The standard of living, education, physical and mental health are all social. And then cultural, the right to take part in culture. So all of the different cultural things that we have in society, different different things that you can go to, festivals, different things like that. We all have the right to take part in our culture. The next part of the syllabus is about principal treaties. So we'll have a look at 4 different principal treaties and the main features of each. So you may recognize this family from Billawheeler, and this is an example of the implications of the Convention relating to the status of refugees from 1951 and the Protocol relating to the status of refugees from 1967. So both of these, this convention and the protocol, provide provisions to protect and support refugees. The purpose was to identify the conditions in which a person would be considered a refugee. So what is the definition of a refugee? And then providing legal rights, recognizing that people have the right to seek asylum from persecution in other countries. So here, through these pieces of these treaties, we understand what a refugee is and what their rights are. So this family from Billawheeler were originally assessed not to be refugees in Australia, and this was the argument that was used by politicians to support their claims that Australia did not owe the family protection. But ultimately, back in 2021, when the Labor government got into power, one of their promises was to allow this family to stay in Australia, and they upheld that promise. So this family is now still living in Billawheeler in Queensland. But you can see how these different treaties and what they say about the rights of people do play a role in political decisions and certainly in the way that refugees and their situations are handled. So, a little bit more of an overview of each of these. So, the 1951 Convention elaborates on Article 13 of the Universal Declaration of Human Rights. So, as I mentioned before, we do have overlaps between different treaties, protocols, conventions, all of the different words we can use to describe them. So the Universal Declaration is quite broad. It's covering lots of different areas and lots of different rights. And then we do have all of these more specific treaties as well. So in this case, we've got the 1951 Convention that's elaborating on those more general principles set out in Article 13 of the UN Declaration. So it includes the core principle of non-refoulement. So that means that a refugee should not be returned to a country, so sent back to a country where they face serious threats to their life or their freedom. It also includes the provision that arbitrary detainment is illegal and penalties are not to be awarded based on illegal entry. So if a refugee illegally enters a country, they can't be penalized because of that. And it also includes the provision of public education in Article 22. So refugees have that right to receive an education in the country that they're in. The 1967 protocol broadens the applicability of the 1951 convention, and it also removes the geographical and time limits that were part of the 1951 convention. So there were different limitations there, and years later in 67 they recognized those limitations and that they shouldn't be there, so those were able to be removed as well. The International Convention on the Elimination of All Forms of Racial Discrimination. This was from 1966, and it requires that racial segregation, criminalization of incitement of racial hatred, and promotes understanding and tolerance. So they want to get rid of racial discrimination and segregation in society. They are saying that inciting racial hatred is a criminal offense, and it's also saying that they want to promote understanding and tolerance in society, so we can all be united regardless of our race. Convention on the Elimination of All Forms of Racial Discrimination Against Women. You can see that different groups of people who are minority groups or have faced discrimination in the past, and in some cases continue to face discrimination, tend to have dedicated conventions relating to eliminating discrimination against them, because over the years it's been recognized that they have discrimination against them, that they are minority groups. So those pieces of human rights legislation have come in to try and help with that. So in this case, the Convention on the Discrimination Against Women outlines all the non-discrimination requirements and also women's rights. So regarding a whole bunch of different areas like political life, representation, and rights to nationality, education, employment, and health. So some main features: the idea of substantive equality, non-discrimination, and state obligation. So let's have a look at what these things mean. So substantive gender equality requires that equality is interpreted according to the broad context or the realities of women's disadvantages and the impact that their circumstances have in terms of eliminating disadvantage. So It's not easy to just compare different groups. It's not straightforward to compare different groups. So this is saying that we need to look um, at the disadvantage that women in particular face, and make sure that this idea of equality is looked at from that broader context to make sure that those disadvantages are factored in. State obligation is the concept that a state that is party to the convention is legally obligated to take all appropriate measures to eliminate discrimination against women and advance gender equality. So it's the obligation of all of the different states that are signing up to this convention. The Convention on the Rights of the Child, 1991. We mentioned the rights of children earlier, so we'll have a bit more of a detailed look here. So, the main feature of this convention is non discrimination, which is all about this idea that children have rights regardless of who they are. So, regardless of race, color, sex, language, religion, political or other opinion, national, ethnic, or social origin, property, disability, birth, or other status. So there's heaps of different things that make each person unique, each child unique, and none of them should be used as something that children are that is held against children. So children should not be discriminated against based on any of these things, and indeed, no one should be, because it doesn't matter what these things are for a person. It doesn't matter what our background is. We should all be treated equally. We should all have the same human rights under the law. So, children's rights in the convention include the right to be treated fairly, to have a say about decisions affecting them. And that's something that's really important because often it's this case of children not having the knowledge and the maturity to be able to make decisions by themselves. And often it's adults making decisions on their behalf. But this convention is recognizing that they should actually have a say about the decisions that affect them, because ultimately it is about them and they are still people. They also have the right to live and grow up healthy, to be safe no matter where they are. They have a right to an education and the right to play and have fun. So, another feature is this idea of the devotion to the best interests of the child. So, the child's best interests must be the primary consideration whenever we're making decisions about children or affecting the child. So, so when we hear about different legal cases in society, we hear about how uh, this decision was in the best interests of the child. That could be from different perspectives. It could be the safety of the child, the health of the child. It could be from an education perspective, um, a financial perspective, all of those different considerations that may play a part in what's in their best interest. So, respect for the views of the child. So, this is the idea that children have the right to express themselves freely on matters that affect them and to have their views taken seriously. So, yes, they are children. They haven't reached that 18-year mark, but they still have opinions. They still have the right to express those views, and to not be treated as lesser than, or to not be treated as though those opinions that they have aren't valuable. They also have the right to life, survival, and development. So there's some very basic ones that would be covered in other documents. So the Universal Declaration of Human Rights, the ICCPR are also covering the right to life. And then we have, for all of these specific conventions for the different groups like women, children, etc., we often have some overlaps, but then also some building on those more general principles, some more specific things that relate to that particular group or that particular issue. So in Australia, in terms of children's rights, we don't have the Convention on the Rights of the Child embedded in our domestic legislative framework. So we do have some child rights issues. We've got this idea of the age of criminal responsibility. So children as young as 10 can be arrested and jailed, and the UN has called for this age to be raised to 14. So when we aren't embedding different legislation, that means that we don't need to follow the convention because we haven't ratified it yet. And in this case, that means that Australia is able to not follow what the UN believes is the right path to follow. Another aspect is child labour. So you must be 15 years old to enter into labour practices. There are some exceptions to this, like in the entertainment industry, you might be doing work there with acting or things like that and be below 15, but that's a general rule. And the right to get an education as well. So school is mandatory for 6 to 17-year-olds. There are, of course, exceptions to that as well. Some students choose to leave school early, but they have to have a job. There are certain requirements there. Have to have a job or have to have another path that they're taking with education, for example. Part 4 of the syllabus that we're looking at is covering the process of treaty obligations being translated into domestic law. So we're going to look at accession and ratification, the role of reservations, and the effect of the Human Rights Act. We'll look at the rights of states. Some of these things we've touched on already, but we're also going to be looking at particular articles in the United Nations Charter. Then the different roles of different agencies as well. Okay, so explaining the process by which treaty obligations translate into domestic law through accession or ratification. So not only do you have to be able to just describe terms, you also need to be able to explain them. And often you need to understand the relationships between things as well. So our analytical verbs describing is less detailed, whereas explaining, we often need to have examples. We need to have enough knowledge to be able to write full sort of paragraph responses to explain things. So that's why here we'll be able to look at examples of how you could explain these different concepts we're going to look at. So, treaty obligations translate into domestic Australian law when they undergo one of two processes. It could be ratification or it could be accession. So, ratification, like we've mentioned, is the process of fully adopting the obligations imposed by a treaty into Australian law. And this is the idea of passing that legislation on that federal level that is mirroring and enacting those treaty obligations. On the other hand, accession is where a nation state, such as Australia, enters into a treaty that has already been formed after it has been negotiated and signed by other states. So it has the same legal effect as ratification, but the difference here is just the timeline of when things are happening. So here we've got this idea of negotiation. So other states may have already implemented the convention or the treaty, but this country, so in our case Australia, may have a delay in doing that, and that would be extension. So the role of reservations. Now, this is important for what we were just touching on. So when you are negotiating as a nation for a nation to indicate it will sign the convention or covenant or treaty, you may also make some reservations. So just like in your everyday life, you may be saying that you're interested in something, but you do have some things that you're not so sure about, and you want to discuss them further and negotiate them. So it's possible to say what those reservations are about the obligations under the conventions. So any kind of protocol amendments or supplements to an earlier treaty or agreement. So let's have a look at an example. The International Covenant on Civil and Political Rights, or the ICCPR, is a multilateral treaty, so it's ratified by many nation states, more than two, and it's binding on states that ratify it. Australia became a signatory in 1980, but it has reserved certain rights in relation to some of the provisions. So, for example, Australia didn't agree to the provision that all juvenile offenders must not be held in custody in adult prisons. So that's why that still happens in Australia, because we've not agreed to that provision as part of the ICCPR, and that's something that other nation states may disagree with, because they may have not reserved their right to go against that part of the convention. So an example of a paragraph response to explain the role of reservations. So it's a unilateral statement made by a state whereby it is basically promising to it, or it's saying that it's going to exclude or alter the legal effect of certain provisions of the treaty in their application to that state. So it's saying overall we are agreeing to this treaty or this convention. However, we aren't agreeing to this specific aspect of it, and we don't need to follow the different things that it's outlining in that section of it. So the role of reservations is to enable a state to accept a multilateral treaty as a whole by giving it the option not to apply those certain provisions which it doesn't agree with or it doesn't want to comply with. So reservations can be made when the treaty is signed or when it's ratified, accepted, approved, or acceded to. You've got lots of different options there with the timing. Reservations must not be incompatible with the object and purpose of the treaty. So, of course, there are some limitations to this. We can't just say, yes, we agree to this treaty, but we're not following this aspect, this aspect, this aspect, because they would get to a point where you're actually not agreeing to anything. You're you're needing mainly to follow the most of the principles in a treaty and then just have some reservations potentially. Otherwise, it would be incompatible. So a treaty can also prohibit reservations or only allow for certain reservations to be made. So if a treaty has certain kind of certain ideas embedded in it that are really important, something that really, if you go against that, if you have a reservation about that, then really it's not compatible with the overall idea of the treaty. That could be stipulated as a reservation that can't be made. Yeah, so there are limitations there to make sure that basically things can work and that everything is compatible. So it's good to have this idea of reservations, but it does have to have limitations for it to function logically. Next up, let's have a look at the effect of the Human Rights Parliamentary Scrutiny Act 2011, which is a Commonwealth piece of legislation. So there are two processes outlined in this act, and the one of them is the requirement of a statement of compatibility to accompany all proposed legislation, and another is the establishment of a parliamentary joint committee on human rights. So we've got to have this idea that all of the legislation that we have in society has to be compatible with other rights, other parts of society, other legislation that already exists. So that's where the statement of compatibility is providing that assessment of the compatibility of that legislation with the rights and freedoms recognized that in the other human rights treaties that Australia has ratified. So in Australia, we've got 7 human rights treaties that we've ratified. The intention behind this is that those that restrict or interfere with the human rights that are recognized in those other treaties will be flagged for reconsideration and possibly amendment as well. So again, this is that idea of compatibility of things that already exist needing to align with anything that is being proposed to be introduced. You can't just introduce everything without considering what's already there. And then the PJCHR has a gatekeeping role. So this is the Parliamentary Joint Committee on Human Rights. So it has to examine bills, legislative instruments, and acts to look at the compatibility with human rights. And it also conducts inquiries into any human rights related issues that the Attorney General refers to it. So the whole idea of this is it's ensuring that when the Parliament is developing policy and legislation, human rights are always considered in the decisions that are made. So when we look at the title of this act, it's about parliamentary scrutiny. So it's about keeping the government accountable, making sure that we've got that compatibility, we've got that oversight, so everything is working together cohesively rather than having contrasts between different things that are introduced. The rights of states. So we've looked already at sovereignty, but let's have a look again. So this is that idea of exercising full control over affairs within a geographical or territorial limit. So it can pass laws and enforce them within that area, and exists as an essentially independent legal and political body in this space. And equality. So sovereign equality is the concept that all sovereign states, so any state that's deemed to have sovereignty, are treated equally in international law, and their right to make laws for their own territory will be respected. So they have the ability to make laws for their area, and that needs to be respected by the broader international society. So the rights of member states are not dependent on size, economic, political, or social power or circumstances. So if you've got sovereignty in a nation state, then it doesn't matter what size or sort of standing or status you have, your rights are the same as any other nation state. Another right is political independence. So this is the concept that within the territorial boundaries of a state, so that same idea of the territory, so again, you can think of the borders of Australia. Within that territory, the state has the right to an independent political system of its own choice, and it should be free from interference from any other state in how that is exercised. So we've got different countries all over the world that have different political systems. Even countries that we are allies with have different political systems. So, for example, the United States has the presidential system, whereas here we have a prime minister. The United States doesn't have compulsory voting, whereas in Australia we do. So we've got all these different political systems depending on the different areas, and every area, every territorial boundary of a state uh, is allowing that state to have the right to choose its own political system and not be facing interference from any other state to try and change that. Territorial integrity is the idea that a state has the right to its own territory, and again, another state shouldn't do anything to infringe that right. So again, when we think of territory, we're thinking of any of the area that makes up that state. So again, the borders of Australia is an example. So let's have a look at some particular articles in the United Nations Charter that are important for you to know. So Article 2.1 confirms the equal sovereignty of all members of the United Nations. So these articles are upholding some of those rights of states that we've just looked at. Article 2.4 of the Charter adopts the idea that the use of force or threat of force against the territorial integrity or political independence of any state should not be the norm in international relations. There is an exemption in Article 51, which is stating that force can be used in self-defense. So again, we just looked at territorial integrity and political independence. So that's where Article 2.1 comes in to protect those rights of states. Article 2.7 ensures the independence of states from UN interference, so United Nations interference, in domestic matters within a state, with the exception of matters that are potentially deemed a threat to international security. So you can see that there are a lot of different things that have stipulations to say that it's not completely absolute. You do have exceptions because while countries do have their own rights, it has to be within reason. They can't be putting other countries and other systems under threat. So, explain the role of the UN, its agencies, and other organizations. So, there are a whole bunch of different organizations outside of the UN and then agencies within the UN that you need to understand and know how to explain. So, we'll have a look at each of these. So, the role of the United Nations is to maintain international peace and security, protect human rights, deliver humanitarian aid, promote sustainable development, and uphold international law. So, this is that idea that we just looked at. For example, in Article 2.7, it was saying that countries have the right to make decisions for their own territory. However, the UN is also stipulating that it can't be at the expense of international security. So that is because the United Nations is uh, responsible for looking after that global perspective, looking after the peace and the security and the human rights in international law globally. So it was formed after World War II to prevent the widespread destruction that happened in World War II from occurring again. There are a bunch of different agencies and organizations. So we've got the World Health Organization, or WHO, the International Monetary Fund, the World Bank Group, and then the UN High Commissioner for Human Rights and also the High Commissioner for Refugees. So let's start off with WHO. So we heard a lot about the World Health Organization back when we had the COVID-19 pandemic. So WHO coordinates action on international health issues, sanitation, and diseases. And the objective is the attainment by all people of the highest possible level of health. The International Monetary Fund, of course, is all about finances and money. So it's aiming to foster global monetary cooperation, secure financial stability, facilitate international trade, promote high employment and sustainable economic growth, and reduce poverty around the world. So all of those things that come under that banner of money, finances, the economy, making sure that it's looking after that on that global level. So this monetary fund acts as a forum for advice, negotiation, and assistance on financial issues. And although the IMF has a formal relationship agreement with the UN, it also retains its independence as well. The World Bank Group consists of 5 international organizations that make loans to developing countries. So it focuses on poverty reduction and improving living standards worldwide through low interest loans, interest free credit, and grants for all of those developing countries that need help in really important areas like education, health, infrastructure, environmental protection, and communications. We've got 2 different high commissioners to look at as well. So the UN High Commissioner for Human Rights coordinates human rights activities and supervises the Human Rights Council in Geneva. So they work to protect and promote human rights that are guaranteed under international law and specified in the Universal Declaration of Human Rights. They also promote human rights that are yet to be recognized in international law. So they're looking at what is needed in society, what human rights are yet to be recognized, and what it can do to help promote those, to bring about better outcomes for everyone, pretty much. And then the UN High Commissioner for Refugees is tasked with leading and coordinating the international efforts to protect refugees and resolve refugee problems across the globe. So the UNHCR works to ensure that everyone can exercise the right to seek asylum and find safe refuge in another state. So they also have the option to return home voluntarily, integrate locally, or resettle in a third country. So another thing to keep in mind, not only do you need to know what these things are, but also just try and memorize the acronyms as well. It's handy to understand what those acronyms are in case you get any kind of question or stimulus that only uses the acronym. It's good to have that understanding yourself. Part 5 of the Topic 1 syllabus, we've got key human rights initiated in these different important legal documents. We've got different acts and then also the Magna Carta. So the Magna Carta came about back in 1215, so it is a very old document, and it provided a modern platform to the provision of human rights and the development of a constitution. So the document is considered a cornerstone in human rights protection in the English-speaking world, and it was modern back in its day. It was something that was really big in society, and it provided many of the fundamental rights that we now see today. So Clause 39 cemented the concept of innocent until proven guilty, which is something that we hear about all the time, and that our legal system follows. And so that's about you're not to be treated as guilty until you're proven guilty by a jury of peers, and you also have the right to bail as well. It also advanced the ideas of freedom, justice, and the rule of law, and these are principles which have become enshrined in our democracy. So it established the principles of due process and equality before the law, such as the right to a trial by jury and not being held imprisoned without the prospect of a fair trial. It enshrined the right of the church to be free from government influence, as well as the rights of all citizens to own and inherit property. And lastly, it guaranteed protection from excessive or arbitrary taxes, and it promoted the right of widows who owned property to choose not to remarry. So obviously we've had issues with lack of equality in terms of gender, and so this Magna Carta was really pivotal in terms of giving widows who've lost their husbands that right to choose not to remarry, even though they owned property. They have the right to own it themselves without needing to marry, so it's under the control of their husband. The Racial Discrimination Act 1975, which is a Commonwealth Act, promotes the human right of equality before the law for all people, and that's regardless of race, color, or national or ethnic origin. And the Act promotes human rights and fundamental freedoms in all different areas. So political, economic, social, cultural, and any other field of public life. So we've got the right to vote regardless of your race, the right to education, and the right to freedom of thought, conscience, and religion. So the Sex Discrimination Act 1984 is, of course, promoting the human right of freedom from discrimination on the grounds of sex, but then also on the grounds of sexual orientation, gender identity, intersex status, marital or relationship status, pregnancy, potential pregnancy, breastfeeding, or family responsibilities, or involving sexual harassment. So you can see that, again, we've got this idea of different discrimination acts that are based on key issues or key areas where people have faced discrimination before, and in some cases continue to face discrimination. The Disability Discrimination Act promotes the human right of freedom from discrimination for anyone with a disability. So they are protected from discrimination in terms of employment, education, access to services and facilities and public areas. And it makes disability discrimination unlawful, and it promotes equal rights, equal opportunity, and equal access for people with disabilities. So some examples of disability discrimination that may exist in society. So a school policy that doesn't allow students with disabilities to go on excursions would be an example of disability discrimination. Any insurance policies that have a blanket ban on mental health conditions. A shop that only accepts a driver's license as an ID, and not everyone has a driver's license for various reasons. Not considering a job applicant who uses a mobility scooter or any other sort of tools or devices that they need to function or to get around. Not allowing a staff member to bring their assistance dog to work. So someone who is visually impaired may need an assistant dog to get around and to work. So not allowing them to have that assistance dog would be discrimination. Bullying a staff member with an intellectual disability is also, of course, disability discrimination. And another aspect of the topic 1 human rights is being able to explain the role of the Australian Constitution. And this includes the foreign affairs power that is in section 51. And this is where we are looking at express and implied human rights in Australia, which is something that I've mentioned a few times already. So this is the last part of topic 1, and then we'll be moving on to topic 3. So section 51, under the foreign affairs power in this section of the Australian Constitution, the Parliament has the power to make laws for the peace, order and good government of the Commonwealth with respect to external affairs. So this idea of foreign affairs power. So this means that the Commonwealth can enact laws which are a faithful implementation of those international treaties or conventions that Australia is party to. And so that means that it's protecting express and implied human rights in Australia. So it can't enact laws which aren't in line with those international treaties. It has to make sure it's aligned with those treaties and then enact laws that are protecting express and implied human rights that are within Australia. So express rights. The Australian Constitution is protecting express rights in Australia by explicitly detailing 5 human rights which Australians are entitled to enjoy. So those rights that we have in our Constitution are the right to vote in section 41, the protection against acquisition of property on unjust terms, section 51, the right to trial by jury, which we've heard a few times, section 80, freedom of religion, section 116, and prohibition of discrimination on the basis of state of residency. So regardless of what state you live in, you should be treated equally and not discriminated against. The express enshrinement of these human rights in Australia acts to protect the human rights by prohibiting any Commonwealth law, so any federal law that could infringe on those rights. So those 5 rights are not able to be broken in any way. The government cannot pass any legislation that goes against those rights or obstructs them in any way. On the other hand, we also have implied rights. So these are rights that are derived from interpretations of the Australian Constitution, but they're not specifically outlined. So we do have that idea that they're open to interpretation, and different interpretations can contrast each other. So the right to freedom of political communication, the right to free speech, and the right to democratic representation are examples of implied rights in our Constitution. So an example of a case where implied rights were relevant. So in Lang versus the Australian Broadcasting Corporation, or the ABC, in 1997, the High Court confirmed the implied right of free speech in the Constitution, finding that freedom of communication on matters of government and political affairs is an indispensable part of the system of representative government. So this right is limited to what is necessary for the effective operation of the system of representative and responsible government. So it's interesting here how an implied right was relevant in a high court ruling. So even though they're not express rights, they still are important in society, and they still can have a bearing on important decision making and outcomes for people.